Speaker, I'd agree with some of what the last speaker said about the principles of the bill. They are, at least on their face, principles that pretty much anybody should support. Obviously, legislation should be consistent with the rule of law. The law should be clear and accessible. It shouldn't adversely affect rights and liberties or impose obligations retrospectively. Every person should be equal before the law, and issues of legal right and liability should be resolved by the application of law rather than the exercise of a discretion on the part of officials, elected or otherwise. Those principles are incontrovertible, and as my colleague Leanne Dalzell said, they are the basis on which the legal system rests. They're the basis on which all the presumptions around our legislation are construed when the courts exercise their ultimate right to decide what it is that we meant when we made a law. Similarly, on liberties, laws shouldn't diminish a person's liberty or personal security or freedom of choice or action or rights to own, use and dispose of property, except as is necessary to provide for or to protect any such liberty, freedom or right of the person themselves or of another person. But again, here we have in the legislation a fundamental principle or canon of interpretation that the courts will use now when they construe legislation passed by this House. They will read laws down if they appear to offend against those principles, and only if this Parliament were to use the clearest possible words could the courts come to a contrary conclusion. Likewise, there's a principle contained in the bill around the taking of property. Laws shouldn't take or impair or authorise the taking or impairment of property without the consent of the owner unless there's a public interest, an overriding public interest involved, and full compensation for the taking is provided, and that it's provided on behalf of or by the persons who obtain the benefit of the taking. Again, something that no one who's studied our Constitution would find surprising. Likewise, taxes and charges shouldn't be levied under any administrative provision. They should only be authorised by a principal enactment, and the charge should only be reasonable in relation to both the benefit the payers are likely to obtain from the goods or services and the cost of efficiency in providing the goods or the services. Again, inarguable. The role of the courts, well, the courts should always have that authoritative right to determine the meaning of legislation, and there should always be a right of appeal on the merits against decisions to a court or other independent body, and there should be appropriate criteria laid down for the making of decisions by the court or independent body. And then finally, there are principles enunciated around good lawmaking. Laws shouldn't be made unless, to the extent practicable, the persons likely to be affected by the legislation have been consulted, and not be made unless there's been a careful evaluation of the issue, the effectiveness of existing legislation and common law, whether the public interest requires that the issue be addressed, any other options, including non-legislative options, for dealing with the problem, the question of who's likely to benefit and who's likely to suffer a detriment from the legislation, all potential adverse consequences of the legislation, including the Crown's potential legal liability that are reasonably foreseeable. The benefits of the legislation should outweigh the costs of it, and it should be the most effective, efficient and proportionate response to the issue concerned. Again, nobody could argue with these principles. They are right, they are self-evident, but they exist already in terms of the way, hopefully, that we evaluate legislative proposals. And one of the problems, sir, and one of the reasons why members on this side have real concerns about the bill is that although it seems to state very fair-sounding principles, very inarguable principles that most would accept without second thought, the way in which the principles would then be applied to legislation are the problem. Because the bill provides that wherever an enactment can be given a meaning that's compatible with the principles, that's to be preferred to all other meanings. And a court can make declarations of incompatibility between a piece of legislation that this this House and this Parliament may make in future with the bill if we were to pass it. Now, the problem then we get constitutionally is if the court does that, the declaration of inconsistency has no legal effect. It doesn't affect the continuing operation of the inconsistent measure, and no court may hold any provision of the legislation to be impliedly repealed or revoked. So what's the point, sir? That's really the question here. What's the point in this legislation? Why bother stating principles that already underpin our constitutional arrangements and then say, and you can get a court to say that a future Parliament has breached those provisions, but if you do, the court's declaration won't mean anything. I mean, what sort of constitutional merry-go-round are we talking about here? What sort of waste of money are we contemplating putting on the statute book by engaging in this exercise? And sir, I just want to run through some of the criticism that I think has been made justifiably of the bill, apart from the problem that I've just identified. First of all, the Regulatory Responsibility Task Force failed to justify why this sort of bill is necessary. There's very little evidence showing why a rigorous or intensive approach is required, as opposed to some of the other options that were canvassed by the Commerce Committee when Mark 1 of this legislation was considered. There's no convincing argument as to why legislation is required to ensure better legislation, as opposed to other means of improving the way that we do things here. And when you actually measure the Regulatory Standards Bill against its own principles, it's clear that no responsible legislator could vote for it. Then there's ambiguity in the legislation. And again, referring to earlier attempts in this area, George Tanner QC referred to the open-textured language used, leading to uncertainty of meaning. He said, it attempts to define good lawmaking by reference to a set of simple principles. In doing so, it obscures the complexities inherent in them and creates the same lack of clarity and uncertainty that it seems to prevent. Sir, I referred to the difficulty that this legislation will create for the third branch of our government, the judiciary, earlier. And Sir Geoffrey Palmer has pointed out in a recent article that, quote, neither the judges nor the legal profession are proficient in policy analysis of the type that leads to regulatory legislative proposals. And in this respect, the Regulatory Standards Bill would confer on the judiciary a novel role for which they're not resourced or equipped. I can hear the cries now from parliamentarians and others who don't like the idea of judges expressing a view on policy and content, and yet here is exactly what is being invited of them by this legislation. We'll get all sorts of accusations around the activist judiciary overstepping the mark and overstepping their roles, and yet that is exactly what we would be inviting them to do by the text of this legislation. And sir, I think ironically, this bill will create more compliance costs than it would save, because the relevant minister or the public entity will need to undertake a certification process. There'll be regular reviews of all legislation, annual reporting requirements by every entity, ministerial oversight of the review, and then the prospect of litigation being generated by the possibility of an application for a declaration of incompatibility. That all implies massive resources, sir, particularly over a 10-year time frame, which George Tanner QC referred to as just unworkable and unrealistic. So, sir, we've got real problems in the legislation. There are better alternatives. The Commerce Committee's already considered those and has said that a regulatory impact statement and ministerial sign-off on compliance with the Legislation Advisory Committee guidelines, if they were taken seriously, would make a real difference here. Why don't we try using what we've got, improving it, actually adopting the principles that the bill would exhort us to do, look at what we've got and decide whether it's actually workable before we embark on an innovation such as this, sir, that will be costly and unworkable. That's my challenge, sir, to the Minister.
Dr. Russell Norman.